Thank you, everyone, for coming. We greatly appreciate it. We would like to begin our proceedings today by acknowledging that we're gathered, speaking, and learning on Lenapehoking, the ancestral lands of the Lenape peoples, which settlers call New York City. We do this with humility and gratitude, while recognizing the violence of forced relocation and displacement of the Lenape peoples, with whom this department and university are in an ongoing process of learning. These peoples are known today as the Delaware Nation in Anarco, Oklahoma, the Delaware Tribe of Indians in Bartlesville, Oklahoma, the Stockbridge Muncie community in Bowler, Wisconsin, and the Muncie Delaware Nation and the Delaware Nation in Moravian Town, both in Ontario, Canada. We acknowledge the need for the recognition of the history of the Lenapehoking, a land stolen from, never traded by, the Lenape people, who continue to live in New York City and beyond. We acknowledge the systemic and ongoing violence of settler colonialism and the genocidal violence that resulted in both forced relocation and physical and psychological trauma perpetuated across generations. We acknowledge, in particular, that settlers have broken and continue to break their treaties with the Lenape peoples, beginning with the actions of Henry Hudson and Peter Minuit in first appropriating this land. We recognize that reparative action requires long-term maintenance and multi-generational efforts to build relationships with the sovereign nations of the Lenape peoples. The story of LGBTQ+ rights in the United States is one of passion and it is one of pride. It's the story of a community that through unimaginable resilience has continued to grow and thrive in the face of generations of suppression, of violence, and systemic discrimination. It's the story of a community that gained acceptance through creative expression, a community that aided in the civil rights and feminist movements, that joyfully fought against bigots in uniform, that overcame a deadly epidemic, and then marched in the tens of thousands to demand equality, a demand that continues today. One of the institutional blind spots of being a law student is that we're often taught to understand movement history entirely through court opinion. Had you taken an average class on LGBTQ+ or family law, you might think that the story of queer struggle began in 1986, when the United States Supreme Court upheld Georgia sodomy laws as constitutional in Bowers v. Hardwick, a ruling, we should remember, that was overturned in 2003 in Lawrence v. Texas. And you might think the struggle ended in 2015, when the Supreme Court legalized same-sex marriage in Obergefell v. Hodges. Of course, you would be leaving out the generations of struggle for LGBTQ+ rights that have taken place outside of the courtroom. And it's this generational work happening outside of the law on the ground that we're here today to uplift. As future representatives of the law, it's our duty to thoroughly examine the potential, as well as the limitations, of legal systems to create a lasting positive future for LGBTQ+ people in the United States. Now, our following speakers understand a great deal about our legal system, having experienced firsthand its injustice and fought tirelessly to remedy it. Please welcome Dee Farmer and Dee Dangaran. Thank you so much.
Hello, everyone. I am Dee, and this is Dee as well. So you'll be getting a double dose of D's today. Dee went to an Ivy League school to get her legal education, and I went to a different kind of school. Some people call it the School of Hard Knocks, but it's really the Federal Bureau of Prisons, where I spent many hours learning the law. And Dee is a dear friend, and we are both come together, even though we come from different paths, to work on the same issue. And I'll let Dee do the introductions.
As Dee said, we are D&D. We're so grateful for the organizers of this colloquium, for their diligent and brilliant work organizing a really powerful set of discussions, and for inviting us to kick things off. Dee and I are sharing space here and also soon in the pages of the Review of Law and Social Change. We're currently working on an article that will be published later this year as part of the review's participatory law scholarship initiative, which seeks to foreground lived experiences in law's injustice. This keynote is not a formal paper talk, but rather a conversation around similar themes as what we'll be discussing in the forthcoming article. I'll introduce us before we dive in. I'm Dee Dangaran. I am a Filipino Black non-binary trans femme from Hawaii. As Dee said, I received a traditional education. I was lucky to be able to attend a college preparatory school on financial aid, which launched me towards attending Yale and Harvard Law School. In college, I added my voice to the long-standing critique of the ways in which mainstream LGBTQ politics at organizations such as the Human Rights Campaign sidelined the trans community and other marginalized subgroups in the focus on assimilationist issues such as marriage and military equality. Similar critiques of LGBTQ legal organizations brought me to doing prison litigation full-time after law school and my 2 clerkships. I understand the importance of responding to the conservative backlash to the gains in LGBT rights, but I was always concerned about leaving incarcerated queer and trans people behind. Now, as Director of Gender Justice at Rights Behind Bars, I litigate at the trial and appellate levels on behalf of incarcerated or formerly incarcerated people who have been abused or have had their medical needs ignored on the inside. I also organize with trans lawyers across the country as co-chair of the National Trans Bar Association, which keeps me in supportive community. And this is Deirdre Farmer. She spent 22 years in federal prison, where she brought hundreds of cases on behalf of herself and other incarcerated people. One of those cases is Farmer versus Brennan, which was the first transgender rights case to be decided by the U.S. Supreme Court. Dee filed her cert petition pro se. In Farmer, the Supreme Court agreed with Dee that prison officials could be sued for failing to protect her from sexual assault. Since her release, she founded a nonprofit organization, Fight for Justice Project, where she is the executive director. She is also a recent graduate of the Georgetown University Law Center's MORCA Georgetown Paralegal Program. MORCA stands for the Mayor's Office on Returning Citizens Affairs. Dee is also a consultant to the National Center for Lesbian Rights, Inc., Transgender Law Center, and GLAAD, that's GLAAD with 1A, in Boston. In addition, she's a frequent speaker and lecturer and has presented at several law schools, including Duke, NYU, Penn, Michigan, and Yale, among others. She has also given keynote addresses for the American Bar Association, GLAAD, and other conferences. Last year, she testified at a congressional briefing, and the week before last, she was selected for the Haymarket Writing Freedom Fellowship for her prolific writings about the plight of incarcerated people. I'm so grateful and lucky to be on sharing this stage with you and just excited for all of the published projects in the years to come. So we thought that we would start off with a 30-year retrospective, given that Farmer versus Brennan turns 30 this year. I think Dee should go first, since I'm 30 years old, and she got to see Farmer through its entire history.
All right.
How did you get into this work?
So I got into this work. I was actually feel like I didn't volunteer into this work, but that I was forced into it. I went into prison as a teenager, and the sentence that I received was abusive in itself. I got 50-year sentence for credit card and bad checks. And when I went into the federal prison system, I witnessed so many abuses, dehumanization of trans people and people that were LGBTQ in general, that I just felt that I could not stay quiet about it. And so I began to study and really didn't know what I was doing, was going to the law library, reading, and began to file administrative complaints about various issues, hormonal treatment, segregation, wrongful pat-downs, improper housing. And these complaints led me to be transferred from one institution to another, and these were all disciplinary transfers. Because whenever you are filing complaints in the prison and you're a jailhouse lawyer or assumed to be one, you are retaliated against, and they don't want you, the administration doesn't want you in the institution, so you're transferred from one institution to another. And eventually I ended up in the maximum security penitentiary in Terre Haute, Indiana, which was a very violent institution. Most of the inmates there were serving life sentences or more, some natural life sentences. And I was in the population about a week when the inmate came into my cell with a knife and beat me up and raped me. And after that, his fellow homeboys, sort of to say, held me hostage in the cell. But eventually, I did report it to prison officials, and I was placed in segregation, where I remained for 1 year under protective custody, which is the same as isolation, segregation. And the only way to get out of the cell in segregation was to go to the law library. Sometimes they would take you outside in a little cage, but I mostly went to the law library daily, 7 days a week, and I stayed in there about 7 or 8 hours a day. And I just began to study and read cases because I found them to be so interesting. To me, they were like people's lives, different stories. And then when I would go back to the tier, sort of to speak, after I would leave the law library, I would get to hear or talk to other inmates about the problems that they had in the population that brought them into segregation. And many of them had suffered the same thing that I had. They had suffered sexual abuse, or they had been physically attacked, or some of them were being prostituted in the population. And some of the physical attacks even include stabbings or getting cut, just horrific things that I see my brothers and sisters were going through in the population. And when I got transferred, that weighed heavily on my mind. And I came up with this theory that because of the vulnerability of myself and the many inmates that I had met in segregation, that prison officials should have known that placing us in this type of environment where inmates don't have anything to lose, that we would be, subject to abuse and that we would be targets. So I decided to file the lawsuit, and I filed it in the district court, and it was quickly dismissed. The district judge did not buy my theory that prison officials could be held liable if they knew that there was a danger. And the Seventh Circuit quickly affirmed the district court. And I filed a petition for certiorari to the Supreme Court, never really believing that they would accept the case, but more so just going through the procedure I had learned or studied in the library. And so I was really shocked, overwhelmed when I learned that the Supreme Court had accepted the case. And at that time, I asked the ACLU if they would represent me, and they did, and that is the ACLU took over, and that is how I got into this work.
I want to follow up on the point that you were trying out this new legal theory, because I think that's super important. There really wasn't anything like a failure to protect claim enshrined in law before your case, and you mined Estelle versus Gamble for enough language to show that your right to safety was being violated because of failing to put you in safe housing. And it spawned an entirely new doctrine under the Eighth Amendment. When you went about it, did you think that's what you were doing? Did it feel like you were trying to create new law, kind of like an impact litigator would? Or did you have test cases? Or did it really just feel like you were seeking what you needed in that moment in any way that you could and had to be creative about how you named the claim?
I definitely was not of the mindset that I was creating new law. It was, for me, for every case that I brought, it was trying to find a way to win, trying to find something that made logical sense that the judges would understand. And for me, it seemed that it was logical that judges would understand that placing a female into a violent male institution would create a danger.
Yeah, and it has withstood the test of time, so I think you were right. We've spoken before about how some of the things that trans people on the inside are asking for today were not in the realm of possibility back when you brought your case to the Supreme Court, or even for years after that. Getting the courts to order the Bureau of Prisons or state departments of corrections to issue electrolysis, wigs, and gender-affirming medical care did not seem on the table until people tried to get it and started to succeed. It takes a lot of bravery, I think, to go out on a limb and bring an argument that no one has made successfully before. And I think so much of my legal training and the traditional legal training of most law schools is about applying precedent. It's a very formalistic application of the law that is. But to actually build a novel claim and to present it in a way that a court rules in your favor for the first time on a new issue requires much more than basic legal training. In that regard, I think traditional legal training is neither necessary nor sufficient for bringing the kinds of cases that we need if we're trying to protect those who are most impacted by the law. It can actually dull the creative thinking of legal advocates who might hold themselves back from making the most creative arguments their clients want them to make. For example, Michelle Koselleck is, to my knowledge, one of the first incarcerated trans people to ask a federal court to give her gender-affirming surgery. She won in the district court, and that was affirmed by the First Circuit in 2014. That same year, after Sylvia Rivera Law Project filed Cruz versus Zucker in the Southern District of New York, seeking to protect the right to gender-affirming care under Medicaid, the governor of New York, I think Governor Cuomo, allowed HRT and surgeries under Medicaid to go into effect by regulation. The case later allowed it to apply to youth as well. Around the same time as that decision, though, the en banc court of the First Circuit reversed the panel's decision in Koselleck's case and denied her deliberate indifference claim for gender-affirming surgery because it found there were two adequate options. And that began the circuit split on Eighth Amendment claims for medically necessary care that we grapple with today. Just for some law here, the Fifth Circuit goes further than the en banc First Circuit's decision in Gibson versus Collier, holding that Texas's de facto ban on gender-affirming surgery did not violate the Eighth Amendment because there's, the court found, an ongoing controversy of the medical necessity of gender-affirming surgery. That was opposed strongly by the Ninth Circuit in Edmo versus Cries Health later that same year. Keohane in the 11th Circuit agreed with Koselleck, holding that no deliberate indifference for the denial of hormone therapy could be found because of a difference in medical opinion of the providers, and that gender dysphoria did not necessitate social transition, such as gender-affirming clothing and grooming items. So we can see the way that the courts move 2 steps forward and 1 step back over time on these novel claims for trans rights, which can be horrifying to a litigator who's seeing the circuit split and wondering how they're going to zealously advocate for their own client. I'm curious about how you think about this. When looking at the circuit split and either bringing your own case or advocating for other trans people, who you might be assisting with a case that might make that split worse, what do? How would you weigh the immediate need with the potential blowback in the larger picture? Because I think trying to control some of that chaos of the law is what impact litigators who are in the LGBTQ mainstream organizations are trying to do. And sometimes there's a disconnect with people on the inside, whether jailhouse lawyers or people who are seeking the help of jailhouse lawyers when they really need help urgently. So how would you advise the lawyers in this room on that question?
So whenever I litigate a case, I am always looking for ways to sort of level negate, especially if there are possibilities of adverse decisions. So if I was litigating a case about sex reassignment surgery, and knowing that the courts have already held that the Eighth Amendment does not necessarily mandate sex reassignment surgery because there is a difference of opinion among so-called experts as to what is the appropriate treatment, then my response to that would be to include a tort claim that would argue that it was medically negligent or medical malpractice to not provide that surgery to this particular person. In that way, I feel that you would be educating the other side through the expert testimony about why the surgery is necessary, and also you would have a more probable success on such a claim than you would on something that the court has already held may not work.
So you're covering all your bases. I think that's brilliant. And that does lead us to kind of a really common question that I think we've faced regarding harm reduction in the short term and abolition in the long term, or structural change for the better in the long term. And I think we might have some different thoughts on this, but I would love to hear you first speak about how your work might be contributing to abolitionist goals and whether you see the kind of litigation that you bring as abolitionist.
So I don't view my work as abolitionist for several reasons. Having spent many years in prison, I experienced and got to know many people who, at the time that I met them, were incorrigible, and they sought and desired to hurt people, and I could not imagine them at that time under the mindset that they were being in the community. That is not to say that they would not change later, but I don't know what if you didn't have prisons, what you would do with them until they did change or their mindset changed. So, but I really do not spend time thinking about abolishing prisons because of the many harms and abuses that I know people are actually suffering with in prison. While I was in prison, I seen people commit suicide. I seen trans woman get killed as a introduction to a gang. I seen people suffer for denial of medical care, and there are 200 or so inmates that die at the medical center in North Carolina every year, and many of them could be out on compassionate release. And there are just so many abuses that trans people go through in prison. From the day they hit the door, they are, strip searched, by male guards, and it's not done with any humanity or dignity. Then they are put into a unit, and from that. Even when they go into the unit, there are going to be other inmates that's going to say, I don't want that, it, him, her, or whatever in my cell. And so they're already feeling rejected. And then once they do find the cell that they go into, then there's always people coming to their cell, harassing them on a daily basis. And then, they can't get into any programs because the inmates don't want them in the programs. The supervisors or counselors of the programs are saying they're a distraction, to the learning of the other incarcerated people. And so with all those things going on, I just feel that my work, it needs to be more focused on helping people now than on long-term abolition.
And before I launch into my own view, I heard you talk about this at Reblaw, because I think though you're not setting the long-term view on abolition, do you see some of the end results of your work getting people out of prison sometimes?
Oh, definitely. I actually have gotten people out of prison on compassionate release. I've gotten people reduction of sentences, and different, even, like miscalculation of sentencing guidelines and different issues. And so in that sense, I think that even with, if you get someone treatment, I think that, in the end, it does help to reduce the population. And so maybe in that sense, it does contribute to the abolishment of prison. The more people that you get out, the less need you have for so many prisons.
Yeah, I think that's the fascinating thing, right? We get so hung up on whether we are, as a label, as an identity, abolitionists. And when it comes to the actual pragmatic work that you can do, regardless of how you define the work, it can have some end result of reducing the prison population. And so I think that I kind of see this tension, as it's often described in prison litigation or in any kind of civil rights-y world, thinking about reformist reforms or non-reformist reforms. I think that it's less of a divide or a binary as we often think it is or make it out to be. And so I've authored a note in the Harvard Journal of Gender and Law called Abolition is as Lodestar. It's the guide, it's the blueprint, it's the path forward. Abolition is part of my utopia, but it's not just a lofty theoretical framework. It's a pragmatic organizing principle that helps us evaluate specific reforms put forth and decide what we want to bring as our arguments and the remedies that we seek. In other words, abolition pushes us to strive towards the kind of changes or reforms that gets us closer to a world without prisons. And I think if abolition is applied, then if a reform is refurbishing or strengthening the state or the prison system, it's probably not abolitionist. If it's helping to get people out, as these examples in the end were, or making the prison smaller or more expensive to keep a person inside, such that it leads to us having stronger claims for compassionate release or parole, or alternative housing, I think it's more helpful and might be considered something in an abolitionist spectrum, or side of the spectrum. And this is a part of our thinking at Rights Behind Bars when we seek injunctive relief for any of our clients, whether individual or class. It's a matter of not seeking more prison staff or more prison beds. It's never seeking a trans-only or LGBTQ-only facility to be opened up, and thinking really hard before implementing a remedy or seeking relief for more cameras, whether body-worn or placed in the facility, because that's increasing the budget of the facility. So in my note, I divided up the potential reforms for trans rights specifically into carceral interventions, which kind of work within the bars and are not doing anything to trouble them, such as gender-affirming housing placements or housing transfers. Non-carceral interventions, which I see as ignoring the bars and helping the person, regardless of the fact that they are behind them. These include name change petitions, gender-affirming medical care cases, and other conditions of confinement cases, things that we would be helping people with out in the free world as well, because at the end of the day, a conditions of confinement case is a housing case. It's a matter of, your poor housing environment. And I think while I call these non-carceral because it's not on its face seeking the freedom of the person out from behind bars, there is a potential consequence or implication of these non-carceral interventions that the facilities, if they don't want to give someone the gender-affirming surgery that you're asking for, might just release the person early. And that's happened in many cases. And so there is a potential decarceral is the next type of claim, and those are the ones that Dee was just mentioning. Habeas claims or compassionate release claims, anything that reduces the sentence time, those are decarceral interventions that's preventing people from spending more time behind bars. That's, as pretty close to an abolitionist pragmatic step as one can take. It's getting people out from behind bars through using the system. And I think if we create more alternative housing options, if people are able to, reduce their sentences, get post-conviction counsel to convince the court to, revisit their claims, it's all using the system that we have in place. It's not disrupting the criminal legal system, but it is helping individuals' lives and it is reducing the prison population. I think the true kind of abolitionist work is both deconstructive and formative, right? We need to simultaneously think about what would a world without prisons look like and what would we put in its place. And I think that final question where you're not letting yourself get to the abolitionist goal as what's kind of driving you is really hard. It's because it's really hard to change the system and change society and find other ways of holding people accountable and keeping other people safe when someone does have a drive in them to do harm. And I think that's reasonable. And I think it's what everyone kind of jumps to when thinking about abolition and pushing back against abolition. But what I hope that these categories show is that the idea and the framing of abolition is a lot more than thinking about that last step. That everything else to get there can be abolitionist or framed in an abolitionist way as well, and that we can move towards abolition together by implementing an abolitionist framework in what we're doing. One of my favorite queer theorists is Jose Esteban Munoz, who wrote in Cruising Utopia, The Then and There of Queer Futurity, quote, "The here and now is a prison house. We must strive in the face of the here and now's totalizing rendering of reality to think and feel a then and there." We have to remember that, and we will get into this in panels later in this colloquium, that trans people have not always been disproportionately criminalized. This is a recent invention, and it's traced to the history, as my friend Whit Washington has shared, of the Black codes, that there is a direct tie to how trans people are treated and how Black people have been treated. We have to remember that freedom is our natural state, and we need to work to get back there, and that's a decolonial work. Back in Hawaii, I was surrounded by a culture that embraced trans people called Mahu, and in my Filipino culture, Bakla people are in the community and ingrained in the cultural values, and so we're not seen as other. We are understood and embraced. And I think we need to both mourn the dead and fight for the living, and that is an abolitionist tenet as well. And so if we can think about doing this work with those principles at play, it's keeping that utopian sense of justice in us and sense of, the world yet to come, while also knowing there are things that we can pragmatically do today to get there. So that's my thought. Do you have any thoughts in response to that?
I agree with you that, the framework is that we are, as long as we continue to do the work that decreases the population, then eventually it would lead to less prisons, and hopefully one day we will get to the final question of, abolishing prisons and what do we put in their place.
Cool. So I learned recently that you were not in the courtroom during the Supreme Court oral argument in your case. Is that right?
That is correct.
And you actually haven't even listened to it in full?
That is correct.
Which I just love that. So one of my most formative, I think, experiences during law school was digging deep into your case, and listening to the oral argument was one of the fun parts of that. And so I'm going to share this exchange that happened during the oral argument. Your counsel said, "Suppose we were making a list of people who would be at obvious risk of sexual assault if placed in a high-security male prison. Women would be at the top of the list, surely, and the risk is so obvious that we cannot imagine a prison deciding to confine women in general population at a male high-security facility. But also, near the top of the list would be someone who had the appearance and demeanor of a woman, a transsexual-like petitioner." Justice Ginsburg responded, "How about a young man with a slight build, youthful, 18, 19-year-old slender male?" Your counsel replied, "One could easily imagine a number of facilities in which a person as described by Your Honor would be at obvious and unreasonable risk in general population." And as I see it, that exchange, which was not formally in the opinion, but was there in the ethos of the standard, I think, shows the quintessential abolitionist analysis behind your failure to protect argument and centering trans people in the litigation that we do. The facts of your case were focused on your trans identity quite clearly, but Justice Ginsburg's question showed how it could lead to a broader ruling. And indeed, the doctrine that your case spawned went far beyond the failure to protect trans people from harm. In that way, centering trans rights through the creativity of your claim, the urgency of your needs, the powerful articulation of the obviousness of the harm you were at risk of, could benefit all people who are vulnerable to attack on the inside, making the Bureau of Prisons liable for failing to consider the safety of each person based on an individual assessment. I've argued failure to protect cases based on disability status, as well as membership in a gang that was obviously at risk of harm from another gang. There's some work to be done to analogize those cases to yours, but there's some case law across the country now that make those arguments plain. And so I kind of think that as we're entering this conversation about queer law and the focus on queer law is so essential, I don't want us to lose that by centering trans women's experiences on the inside, we are really thinking about the revolution for everyone on the inside, and that there are direct implications. And I asked you before, have you brought and yourself because you're not a lawyer, though I think you are, have you assisted a non-trans person with a failure to protect claim since Farmer versus Brennan was decided?
Yes, I have. I assisted a heterosexual male confined in Illinois to bring a failure to protect claim for sexual assault. And
how did the argument feel different?
It felt different in that it was difficult, if not impossible, to articulate what was obvious that the prison officials would have known that he was in danger.
Yeah. So I think that leads me to the next and penultimate topic I'm planning for us to discuss here. We started late, sorry y'all, but I think I'll try my best to get us back on time. But we have about 15 more minutes of content before we open up to Q&A. And that's where the farmer progeny has brought us. I'll pitch to the room the working title for our article, which I haven't even run by you yet. So very working. Farmer at 30, historicizing trans rights in prison through an intergenerational dialogue. What do you think? Yes? Yes? Okay, cool, thanks. I think the word historicizing is hitting on two meanings. The first one is kind of a bummer. We can lament that farmer at 30 is a quite decimated farmer in some ways, because some of the circuit courts have recently been holding that Farmer versus Brennan did not create a Bivens context for the damages remedy against federal officers. We are thus historicizing Farmer in that courts have made it part of the past, no longer present. An old regime before extending the Bivens remedy became a disfavored judicial activity. This is not universal yet, and there are strong arguments against the position. In the Third Circuit, for example, in Bistrion versus Levy in 2018, reaffirmed by Shorter versus United States in 2021, Farmer was found to be a Bivens context. So a failure to protect suit would make federal officials liable for damages. But the court is revisiting that question again in Kalu versus Spalding, which has been argued in his pending decision. The Ninth Circuit in Marquez versus Rodriguez recently aligned with the Fourth Circuit's decision in Bulger versus Hurwitz in holding there is no Bivens damages remedy for Farmer's failure to protect claims. And I argued Marquez, and I don't think it was my fault. I think the court is just applying some very rigid Supreme Court precedent, and I would argue applying it incorrectly. So we also have an opportunity. That's kind of the first meaning of historicizing. And the second meaning of historicizing, we have the opportunity now to offer a corrective. Many circuits have not yet reached the issue, and the Supreme Court has not opined on Farmer explicitly. We have the opportunity to historicize your case in that we are solidifying the history of trans rights on the inside by correcting the record of what Farmer signified. We've been doing some research together, and you lived the case. And I think what Farmer itself doesn't show, if you just read the Supreme Court opinion, is the before and after. And so what happened on remand after the Supreme Court issued the decision? Did the Supreme Court itself first issue any statement about the Bivens cause of action? And did the Seventh Circuit upon remand find anything about the damages remedy, the Bivens question? Because I think all of this is on the table for appellate arguments, including to the Supreme Court. So what do you know of the history of your case post-Supreme Court remand?
So from Farmer versus Brennan was solely a Bivens case from my perspective. The defendants, they were individually named when I brought the case, and they all filed individual affidavits giving particularized reasons why they lacked knowledge to be held liable for the sexual assault that they claimed that they were not personally involved enough to know that I would be in danger. In fact, one defendant said he didn't even know I had been transferred there. And so from that perspective, I believe that Farmer went to the Supreme Court as a Bivens claim. And I don't really see how it could be anything other than a personal damage suit, because the only other thing it could be would be an injunctive suit, and injunction looks forward, not backward. And the Supreme Court was saying you could be held liable if you had knowledge of what had happened, not what would happen. Of course, you can't have knowledge of what will happen because it hasn't happened yet. So in that respect, I think that Bivens was, Farmer was a Bivens context suit. And I think on remand, the case went to the district court, back to the Court of Appeals, just in sequential order, and then back to the district court, and he threw it out immediately again, and it went back to the Seventh Circuit, and they did recognize that Farmer had a damage claim issue that was upheld by the Supreme Court.
So this is a ripe issue. It's a current issue, and I hope that people pay attention to it because we're seeing right before our eyes not just the erasure of the history of the Seventh Circuit's decision, but of the court's obvious findings. Sometimes the Supreme Court says something like, we assume, for the sake of argument, that this is a Bivens claim, and we reach only the standard. But the court did not do any kind of qualifying of its decision in that way, if you read Farmer on its face. The logic behind finding Farmer not a Bivens context recently is that the court has been saying there are 3 previous Bivens contexts that we have found. And Farmer's not listed in that. It's Carlson, Bivens itself, and Davis. And so there are arguments that Farmer fits under Carlson. It's an Eighth Amendment claim, and it's also seeking the health and safety of the person's protection. But also there's the argument that Farmer is a Bivens context, quite obviously, because the court decided it. And so I think that, there are arguments to be made here, and if folks are interested in talking more about that, reach out, and that's going to be really the focus of our article. I think we want to end by just talking about, if there's a little bit of time, we could save some of this for later, I think, but we wanted to talk a little bit about the work that we're doing now. So Dee, do you want to kick us off?
Sure. So the work that I'm currently doing, I'm currently working to have the attorney fees provision of the Prison Litigation Reform Act either held unconstitutional or eliminated by Congress. The attorney fees provision of the Prison Litigation Reform Act, better known as the PLRA, it restricts the fees that an attorney can get for representing a incarcerated person on a civil rights act claim. And because of this provision, many legal organizations have folded or almost, brought their prison litigation to a minute, non-existent, not accepting new cases, and private attorneys are no longer willing to do prison civil rights litigation because they are having to expend more money than they will get paid for it. And I believe that the provision is illogical and illegal. I believe it's definitely illogical because the purpose of the PLRA, at least the stated purpose, is to reduce frivolous litigation by incarcerated people. And so in that respect, I understood many of the provisions of the PLRA. For example, they require you to exhaust an incarcerated person to exhaust administrative remedies before they can file a lawsuit. And I understand that by having someone present their issue to the prison administration first, that may resolve the issue and thereby reduce litigation. The same is with the court filing fee. They now make the incarcerated person pay the court filing fee, or at least promise to pay the court filing fee, and they take money out of the incarcerated person's commissary account regularly. And I understand that too, if a person is going to have to pay, they're not going to think twice about, the suit that they bring. And then they have another provision that if an inmate has brought 2 or more frivolous actions, that they can't automatically bring a new suit into the court. So I understand too that this is a history of someone filing frivolous actions, so maybe they're following another one. But what I don't understand is while an attorney has an ethical obligation not to file a frivolous lawsuit, I don't understand how this provision has anything to do with the purpose or stated purpose of the PLRA. And then there are people incarcerated who cannot read and write. There are people incarcerated with mental illness. There are people incarcerated who are sick and dying. And these people don't have the ability to represent themselves, and they need an attorney, but yet they can't get one because of this provision. And yet no bar association has stood up and said that this is wrong. No judges, and there's over 100 lawyers in Congress that have voted for this, and I really don't understand it at all.
Just to add some color to it, the rate is the attorney's fee rate is hooked to the appointed counsel in a federal statute of appointed counsel, and it's 150% of that hourly rate. Right now, it is $258 per hour for a successful appeal or case. And just looking at DC's matrix, an attorney who is 0 years out bills at $467. I currently, 3 years out, and according to this Fitzpatrick matrix, would set my billing rate at $520. Attorney 10 years out is $625. And so firms might charge outside of this matrix, either above or below, often above. And then, of course, the other side, when you're a civil plaintiff, the other side is going to be arguing for a different number. But this is really a floor. And it is for an organization like Rights Behind Bars, it is grant-based rather than fee-based. It doesn't hamper us from doing our work. But for many organizations that do require fees and fee-generating cases to sustain themselves, this is it really prevents them from bringing these cases and choosing. They are forced to choose other parts of their docket over these types of cases if they were previously doing the work, as Dee said. Great. I think for the sake of time, I'll stop there and we can talk about reentry and ADA later in our panel. But those are some other topics that I think we're working on right now that ADA is the Americans with Disabilities Act, that we're both very excited about talking about. But at this point, I think we'll turn to questions from the audience, if there are any.
I think we'll hold off on questions now and take a 10-minute break, and then we'll come back at 3:50 for our next panel. Thank you so much, D&D.
Okay, thank you.
Thank you.